Okay, we are live on YouTube. Thank you.
All right. Good morning, everyone. This
Morning.
is the, good morning. Yes, this is the July 9th Board of Appeals. It's being hosted here at the Planning Department. This is going to be a two-part meeting. And so the first meeting is the Board of Appeals public hearing for rulemaking. We're using the Zoom platform. It's held in accordance with the provisions of Chapter 92-7 of HRS as amended, Section 69.2 of the Charter of the County of Hawaii, and Rule 1-5 of the County Board of Appeals, the Rules of Practice and Procedure for these proposed amendments of the Hawaii County Board of Appeals Rules of Practice and Procedure. I'd like to remind everybody, given our environment, of our aloha etiquette. One person should speak at a time, no side conversations. Please mute your device unless speaking to improve our audio. Raise your hand and wait for recognition by the chair before speaking. Prior to speaking the first time, please state your name. Speak slowly and clearly and as close to the microphone as is practical. Limit your distractions, which of course is your cell phones, your families, your friends, and your children. And we'll try to take a break each hour should it come to that. I'd like to introduce the members of the Board of Appeals. Stacy Aguiar. Good morning, Stacy. Can we hear you?
Good morning.
Hi. Good morning. Richard Henderson.
Good morning, Chair. Nice to be here.
Thanks, Richie. Springer Kay.
Good morning.
Hi, Springer. Justin Lee.
Good morning.
Good morning, Justin. Matson Davis is ill today and won't be able to attend. Daniel Neil Thomas.
Good morning.
Hi, Neil. We have our counsel of the board, our deputy corp counsel, is Laureen Martin.
Good morning.
Our staff from the department is April Supernaut.
Good morning.
We're supported by Keiko Mercado.
Maybe just Rob.
Oh, is it just Rob Leisure today?
Yes, it's just me today. Thank you.
And then we have Kim Tanaka, our secretary. Also in attendance, do we have Mr. Zendo Kern?
Good morning, Plan Director here. Thank you.
Thank you. And do we have your counsel?
We do. Jean Campbell here.
Hi, Jean.
Good morning.
Deputy Director.
And is our deputy director here?
Good morning, all.
Hi, Jeff. Okay, we've introduced the members. I'd like to take statements from the public on items on this agenda. This is the rulemaking agenda. So is there any testimony on rulemaking?
Yeah, this is Corey Harden. Tell me when you're ready.
Oh, good morning, Corey. Yes, yes, we're ready for testimony. It'll be in the normal form, which is you'll be given 3 minutes. You did not provide written testimony today, did you?
Yes, I sent written testimony maybe a week or 2 weeks ago.
Okay, we're searching through the files now. As you know, you don't need to read that testimony into the record. We will have it and distribute it to the members. Do we have it, April?
Making sure, but she could go ahead.
Yes, so Ms. Harden, you can begin your testimony.
Okay, so Corey Harden, speaking for myself, commenting on Communication 302 regarding EnerGov. It looks like it's a very promising system. In fact, it may be working already. I emailed asking for some documents on a Saturday night during the 4th of July weekend. Normally it takes days to get documents. And within 15 minutes, I had the documents in my inbox. And so kudos to the planning department, and also appreciate all the work to set up this electronic system. However, I do have some concerns. I think the revisions should be written so anyone who can now submit documents will still be able to do so conveniently. There's a lot of people who have no internet access. About 30% of people in Pahoa have no broadband coverage, according to Broadband Now. Some people can't see that well, or they can't do fine motor or have other limitations. So even if you provide them a kiosk where they can type in stuff, they might have trouble. So it should be accessible to everybody. Also, supposedly the rules are non-substantive, but some of the rules seem substantive. For example, delinquencies such as bankruptcy or similar matters would no longer be grounds for denying a permit. Also, people would need to wait 40 days for meeting minutes to be completed under the new rules. Right now it's 30 days. I wish you'd keep the 30 days. And I also wish planning would put an audio recording online shortly after the meeting. The Board of Land and Natural Resources does that. And because of electronic communication, events move more quickly than they have in the past. And so timely information is really important for meaningful public participation. Also, in some of the rules, postmarks will no longer be used as the date of filing. So if there are mail delays like we had maybe 6 months ago under DeJoy, that could really mess up someone's action. And lastly, there's a couple places that we need to be more specific. One place that says document includes electronic communications such as electronic mail, etc. I think etc. should be spelled out. And one place that says bankruptcy or similar matters, that should be defined. So again, thanks to the planning department, and hope you'll take a look at these concerns. Thank you.
Oh, thank you, Ms. Hardin. Exceptional. Your timing is to the 10 seconds, so you're well practiced. Thank you.
Chair.
Yes?
I'm sorry. Hi, this is April. Ms. Hardin, is she still on the line? She's not on the line. Okay, we don't have her written testimony.
Ms. Hardin, are you still there?
I'm still here. I can resend it. I did email it in quite some time ago, but I'll resend
I really
it.
appreciate that. For some reason, I don't have it in the folder or in the file. So if you could send it to the Board of Appeals email, I can get it immediately and distribute it to the members immediately.
Okay,
Can
I'll
you do that, Corey?
Yes.
All right.
Thank you so much. I'm
Thank
sorry
you.
for the inconvenience. Thank you, Chair.
All right. Okay, thank you. Is there any other testimony from the public on the matter of rulemaking? If not, I'll read it into the agenda. The Planning Department's petition for proposed changes to the Board of Appeals Rules of Practice and Procedures, 21-000300. These proposed amendments to the Hawaii Board of Appeals Rules of Practice and Procedure include changes to allow for electronic filing relating to processing of petitions in preparation for the EnerGov permitting software launch. Notice of this meeting was published in the Hawaii Tribune Herald and West Hawaii Today on June 9th, 2021. The proposed changes were published on the Board of Appeals County website and hard copy mailed to those so requesting. Is there any public testimony on the proposed rule changes? Really? We did that. Sorry. I have a script and I follow it. If all of the testimony is in, I will entertain a motion to adjourn. We'll take a roll call vote after that. Please, can I have a motion?
Neil Thomas moves to adjourn.
Thanks, Neil. And a second? Richie Henderson has provided a second. The motion is to adjourn. Can we have a roll call vote?
Yes. Motion is to adjourn. Mr. Thomas?
Aye.
Mr. Henderson?
Aye.
Ms. Aguiar?
Aye.
Ms. Kay?
Aye.
Mr. Lee?
Aye.
And Chair McCulley?
Aye.
Motion passes.
Thank you. I'm going to call the following meeting to order. This is the Board of Appeals regular July 2021 meeting being held virtually using the Zoom. Our online protocols continue, as read into the record earlier. The Board of Appeals members are consistent. It is, for the record, Stacy Aguiar, Richard Henderson, Springer Kay, Justin Lee, Daniel Thomas, and myself, James McCulley. The agenda items that have been continued or withdrawn include Silber, BOA 20-000241, continued to October 8th of this year. Jensen & Jensen, BOA 20-000267, continued until December 10th. Chris Olcott, Board of Appeals 20-000283, continued till August 13th of 2021, our next meeting. Lloyd and Julie Talbert Trust, Board of Appeals 20-000290, continued to September 10th, 2021. At this time, are there any members of the public who wish to testify on any of the matters on the agenda, including the continued ones, if you so wish? Is there anyone to testify?
April, would you like me to announce the list?
Yes, please. Thank you.
Okay. Yes, Chair, we do have 4 members of the public willing to testify today. The first being Caroline Segala on the Chris Olcott BOA 20-000283.
Okay, Ms. Segala, we have basic rules that we take written testimony and allow oral testimony. The oral testimony is limited to 3 minutes per testifier. And the general request is that if you've submitted written testimony, that you don't read that testimony into the record, but you provide support for the testimony. Do you understand?
Yes.
Very good. Okay. With that, I'll bring you into the meeting and I'll begin your timer. Please provide your testimony.
Hello, my name is Caroline Segala. I reside at 133461 Pomaikai Street in Pahoa. I ask that the Board of Appeals please uphold Hawaii County Planning Department's notice of violation dated October 30th of 2020. Mr. Olcott's continuous disregard of the law and violations of the zone's regulations are reasons why I strongly feel that the Board of Appeals should not withdraw the NOV. As you saw by our previously submitted 30-page testimony, we've tried countless avenues to have our concerns heard and addressed, but all has been in vain. The Board of Appeals is our last chance at maybe being able to live peacefully on the street, and you are basically our last hope. I don't understand why certain actions have been and have not been taken in regard to the enforcement at his lot. Mr. Olcott has been operating a junkyard and auto repair since 2019. It's documented that he has also allowed illegal activities to take place, as well as allow people to reside this non-habitable Quonset hut. He was granted an electric permit in March of 2021, and it's tied to an unpermitted and expired 2001 building permit number 010749, when the regulations clearly state that electrical permits are issued for work on construction having a valid building permit, and this clearly is not the case. Since the building permit was submitted back in 2001 and no action was taken on that permit, then it should be considered expired according to county regulations. And my mother, she has a lot next to Mr. Olcott. She's also not been able to build on her lot because it's clear that the Quonset hut is encroaching on her property. Can the board please consider conducting a site walk to see the condition of the property and see the encroachment of the Quonset hut? All of the statements made by Mr. Van Leer were erroneous and misleading. Therefore, an in-person visit would highlight our concerns. If for some reason the Board of Appeals should reverse the findings of the Planning Department, we ask that they please consider a condition of approval that requires Mr. Olcott to, 1, add screening like a fence or some continuous screened hedge to sufficiently screen the Quonset hut. Maybe, I don't know, insulate it from the noises that come. Hopefully there won't be noises because it'll be a permitted use. Require that he apply for a new building permit since the one from 2001 is expired, and verify with the building department if the electrical permit issued in March of 2021 was done erroneously since it's tied to an expired building permit. And number 4, ensure that the county properly enforces all current and future uses on this lot. We've been through the ringer with this property and the uses that have gone on there, and we're exasperated We wanted to live here peacefully, and it's not something where we can just pick up and move. We don't want to, but we do hope that the Board of Appeals takes our concerns seriously, and we hope that you do the right thing. Thank you.
Okay, Ms. Sagala, thank you very much for your testimony. Florida Roldan, is she available?
Yes, I am available. Hello, everybody.
Hello, good morning.
Morning, how are you?
Please begin your testimony. We're
Sure.
fine, thank you.
Hello, my name is Florida. I'm a resident in California, 15455 Sherman Way, Van Nuys, California. And I own 1 acre of the lot adjacent from Mr. Olcott property, which is purchased in February of 2018. My TMK is 13037061000. I asked the Board of Appeals, please uphold Hawaii County Planning Department notice of violation, the site decision date on October 30, 2020. When I bought the property, the land out back behind the Homestead had a lot of trees and was free of junk cars. There was also some buffer that screened the lot more than now. After Mr. Olcott purchased the property and I was able to visit my lot on several occasions, I could see that he had created a junkyard out the back with trash all over the lot, in front of the side and rear. I could see that the building was too close to my property and I should be removed or relocated to a proper setback. Since I'm not resident in Hawaii, I asked my family who lives next to my lot and the 2 lots over from Mr. Olcott, please send complaints on my behalf for his violation. It was obvious that Mr. Olcott was using the lot in ways not permitted in this zone. And I learned that the property was being used for drug dealing, and it was sad to see that no one in the county was addressing this issue, causing a lot of stress for my family and me. I have delayed the construction of a home on this lot due to not knowing whether all Mr. Olcott violations will continue. Can the board conduct a visit to see the condition of the property inside and out, and to confirm that his building is too close to my lot line? If the board appeal should reverse the findings of the planning department, I ask please consider a condition of approval that requires Mr. Olcott first, add screening like a fence or continuous screening hedge to screen the building. Second, I reply for the new building permit showing existing conditions. And third, only use the lot per the allowed use in this zone. I just want to have a peace of mind when I do the construction in there. So I'm pleased if you take this consideration and do whatever it takes to have. It's a nice community. It's a nice family community, and I want to be in there to live peacefully. Thank you, sir.
Thank you, Ms. Roldan. Daniel Nalton.
Hi, Chair. This is Rob. I'm actually on the phone with Daniel and his wife, Jennifer, and they're having a lot of trouble connecting. Yes, Jennifer. Sorry, my apologies, Chair.
Okay. How are we doing now?
Okay. Yeah, one moment. I think they tried by phone and they're unsuccessful. Then they're trying to connect by Zoom and unsuccessful. So I'm not sure what it'll take to resolve it. I don't know if there's a way to come back to it once we get them in.
Well, one thing for certain is that at the if the Olcott matter goes to the board in August, they'd have their opportunity to testify at that time.
Sure. Okay, I'll let them, I'll make them aware of that, but then should I continue to try to connect them?
Please hold a second. Yeah, Rob, continue to try, and if at some point we can include them, we will, in order to keep things efficient. But otherwise, reassure them that they'll always have their opportunity to testify on the matter if we hear the matter.
I will do so. Thank you very much, Chair.
Yes. Okay. Jennifer Rovtek.
Same thing.
Oh, Daniel. That's Daniel's wife. Okay. I apologize for that. All right. So is there anyone else to testify on this matter? Yes. Identify yourself, please.
John Sagala.
and I live at
Scala?
133461 Pomaikai.
Yes.
Okay, so is this the beginning now of my 3 minutes?
Yes, you're on the clock, sir.
Okay, so as my wife has stated, you know, we've sent in 30 pages worth of documentation with photos, police reports, letters from the prosecuting attorney's office, letters from the police department. So this isn't to us just a petty matter of we don't like your flowers or you make too much noise. I have so many more things I need to be doing with my life rather than complaining about a neighbor. But it's more than just a petty thing. This is a thing where we have a drug dealer in there who was selling hard drugs, not like selling marijuana, selling heroin, things like this. And the place has been raided twice by the police department. They come down, they bash the door, they take people away, they arrest people, there's drugs found. And that's, you know, that has a lot to do with the planning department. But we're trying to set the stage to let you know that we're not dealing with people that we can be reasonable with and have a conversation. I've tried many times. In fact, when I did, you know, try and deal with them, it was pretty hostile. And as you probably will notice when you see the packet, we've received threats in writing, you know, that would be harmed if we continue to complain. So based on that, I'm not going to keep quiet. I don't respond to threats in that manner. And I'm here to say that we want things to change. So, you know, we can live peaceably. My wife stated, you know, we can't just uproot and go. We've invested a lot in our property. We put a lot of care into it. And we've gotten to know some of our neighbors, and we really enjoy being members of the community here. And we've had a lot of difficulties trying to get action on this and justice. I can honestly say the only department in the county has been the police department that's come through and it helped us, and they continue to check in on what's going on even when they're not called. Planning department, not so good. They refused to come down to even inspect the property. They said it was too unsafe. I had to take pictures and do the legwork on my own to prove that there was direct violations. You know, 16 automobiles at one point back there. You know, things like that. I shouldn't. I'm not a paid employee of the county. I shouldn't have to be an investigator or a litigator. But that's what it's come down to. I've had to wear a lot of hats to get some action here for my mother-in-law and my family, and it's frustrating. So what I'd ask of you is to consider all of the things we've presented here. It's not just an issue where we're upset with noise or smells or sights or people walking onto our property thinking it's part of the warehouse because they want to buy drugs. This is all something that's very difficult for us to go through on a daily basis. You know,
yes,
we don't.
Mr. Sagala, thank you. That's the 3 minutes, but I have a question for you, if you don't mind.
Go ahead.
You alluded to some of the issues you have, and one of them had to do with some form of harassment. Who is Melissa Duncan? She's not Olcott. She's not
I don't know if they're married, but she's the woman that lives with Mr. Olcott. I don't know if they're like some kind of a partnership. I assume it's his girlfriend, but she occasionally comes to the warehouse to do some maintenance things, and she stated to us, and you know, that's who it is.
Yeah, I was going through the record, and I was just curious because she's not the named party, and she's not one of the testifiers, and I'm just curious what her involvement was with you, since you are named.
Right.
Yes.
Right.
All right. So, Mr. Scala, thank you for your testimony. All of the testifiers, there's no restriction on your ability to come to the next meeting. This testimony can suffice and should suffice for your position. But if we continue this, we've continued the matter. And if anything new occurs and you have something new to contribute, then you could come and testify again.
Oh, we'll be happy to.
Daniel and Jennifer are on the line now. Rob, just let me know.
Okay, so the other testifiers are available to testify now. So Daniel Nalton, are you available? Daniel?
Yes. Can you hear me?
Hello. Yes, Mr.
Hello,
Melton,
I'm
I'm
here.
going to begin. Yes, I'm going to begin your 3 minutes. Would you please identify yourself and your position on the matter?
My name's Dan Knowlton. I live across the street from this property that's under discussion. I've been here a long time before Mr. Olcott took over the property. I live here with my wife. We've had a number of problems. I'm not sure where to start. I had very short notice as far as the planning department. I wasn't notified about any of this, but let me go on. Okay, so this warehouse next door has had junk cars delivered by tow truck operators. It's had a motorcycle repair shop with unmuffled engines running hours, any hours, day, night, auto repair shop, heavy equipment repair. There's been more traffic many times into that warehouse, drug traffic, than all the other cars on Pomaka'i Street. My wife and I have met every police officer in the Pahoa Police Department. They've been down here that many times. I don't know how many times we've called. How many times I've talked to Mitch Roth about the situation there. He's been very responsive. The planning department had every opportunity to shut this thing down. This has been a top priority of the neighborhood, the board of directors of the subdivision, the local police, the vice squad in Hilo, and the district attorney's office. And I don't know what it takes to deal with this. The building itself is part of the problem. It attracts problems. Before Mr. Olcott had it, squatters were in there. They were just smoking meth and stealing things in the neighborhood. But the drug dealing got much worse after Mr. Olcott took over, and the noise and the problems over there. I'd like to see this building removed or shut down so that it can't be used for any purpose like this again. I signed up to live in a neighborhood with single family homes, not across from something like this. And this is a violation of everything in the planning and building department. I'm not sure if there's anything over there that's not a violation. It would be easier to look at it from that point of view, really. And I guess that's about all I have to say. I had a real bad accident and I'm still being treated for a brain injury for the last year and a half. And to add this, to what my wife and I have had to put up with that, it's been so unnecessary. And I'd just like to see a real strong response from the planning department. Thank you so much for your time.
Thank you very much, Mr. Knowlton. Good luck with your health issues. Ms. Rovtek? Jennifer Rovtek?
I'm Jennifer.
Yes, hi. Would you like to testify?
What Dan said was fine, and my
excuse
concerns
me,
are that
excuse
the
me.
property.
Jennifer, excuse me, could you read into the record who you are and what your involvement is in the matter, and then provide your testimony?
My name is Jennifer Rovech, and I live here at 13-3456 Pomaikai with my husband, Dan Knowlton.
Continue.
Okay. My primary concern is that the property was reported to me as paid by Jack Brenhaw, who is now in federal prison. He told me personally that he had bought the property. The property was put in the name of Chris Olcott to avoid reclamation. And my fear is that because of the past history of problems with Brian Arthur and inviting in people who were stealing and doing drugs, and because Brian is an associate friend of Chris Olcott's, and because Chris is a friend of Jack Brenhaw's, and because Jack Brenhaw is now in federal prison for arms and heroin and fentanyl, that this will revert to the same problems if Jack is out of jail. It's a scary property to live opposite, and I'm nervous that things will revert to what they had previously been. Thank you.
Thank you very much. At this time, I'd like to advise the board and the public for the record that in the previous hearing for rulemaking, we received verbal testimony from Ms. Corey Harden, who stated that she had included written testimony in previous emails to the department. We are in receipt of that, and that testimony has been forwarded to all of your emails. So at this time, you should have the testimony that Ms. Harden referred to regarding rulemaking. Okay. Are there any other testifiers on the behalf of the Olcott matter 20-000283?
No, Chair, we don't have anyone else.
Okay, thanks, Rob. I'm going to close the public testimony. I'd like to thank the public for testifying. I appreciate your involvement in the matter, and good luck. Yes, do you have a question, sir?
Why is the matter postponed till August?
It's a continuance, and with the Board of Appeals, we allow matters to be negotiated between the parties to come to an agreement. For instance, if Mr. Olcott were to concede various things, or if the department were to investigate and determine various things, they could change the matter that we would then hear, or they could resolve the matter completely between the parties.
I see. Oh, thank you for your explanation.
Yes.
Yeah.
Okay.
I appreciate it.
Yeah. Thank you. Are there any other questions?
I just wanted to add. This is Jennifer. I just wanted to add that personally, I am on good terms with both the Segalas and with John and Chris and Melissa.
Okay. All right. Thank you for that. All right. At this time, I'm going to close the public.
One more question. Just please do the best for everybody so we can live in peace in that land. That's what I'm asking you. It's in your hands to solve the problem. Please do it for the safety of our family and everybody there who is living there. Thank you, sir.
I'd like to say one more thing, if I may. May I say one more thing?
And who is this?
This is Dan Knowlton again.
Okay, yes, Mr. Knowlton.
This has been a very dangerous situation over there, as I think my wife hinted at. And we're not talking about simple matters over there of some disagreement between neighbors. We've had gunfire over there. We've had violence over there. We've been afraid for our life over here. This really needs to be dealt with severely. Thank you so much.
Okay, I'd like to reassure the members of the public that are testifying that the planning director is here, and he's heard what you've said. We have our corp counsels here; they've heard what you've said. So there are people paying attention to this matter. So I'd like to reassure you that the wheels of justice may grind slowly, but they grind on. So
thank you so much
for your patience.
I'm so glad about that. Thank you.
You're welcome. All right, so at this time, I'm going to close public testimony, and the board is going to continue with the planning department's petition seeking specific rule amendments. We have a format. The planning department is going to present their proposed changes. The board members can ask questions of the planning department.
You have to read it in.
Okay, read in the rule matter? Yeah. Okay. For the record, the Planning Department's petition for proposed changes to the Board of Appeals Rules of Practice and Procedures is 21-000300. So again, the Planning Department will present the proposed changes. Board members can ask questions of the Planning Department relative to the changes to ensure that the proposed changes are clear to them. So at this time,
You have to take the motion, and then you can do the presentation and have a discussion.
All right, so we'll open this with a motion from the board to approve the petition, to deny the petition, or to approve them with modifications. We then have our discussion and a roll call vote, at which point the motion may be modified, but first we'll deal with the motion. All right, so at this time, can I have a motion from the board? Yes, Springer.
Chair, I'd like to move that we approve the changes with modifications.
Thank you, Springer. Do I have a second? We have one from Richie Henderson. All right. We will now have a discussion, and for that, can we begin? We have the proposed changes in front of us. Do you have questions for the planning department, any of the members? Yes, Neil. I'm sorry, Justin.
Okay, either if Neil wants to go first, that's fine.
Neil, do you want to go first?
Oh.
Justin, I'm going to stop talking now. You talk. Justin, you talk. We have our Zoom trap going.
I apologize. Okay. I'll just list my 3 questions, and then we can tackle them. The first is on page 1-2. It has to do with the definition section, specifically the changes to the addition of a definition for signature. I guess my question is if there was any thought of any clarification what electronic signature means. It seems a little vague. My second question for the planning department is on page 1-5. It has to do with section 1-5, subsection H4. This echoes the testimony of the member of the public with regards to changing the availability of the minutes from 30 days to 40. I was just curious as to the rationale behind that. And then lastly, page 2-2, relating to section 2-4, subsection B and C. I guess it's more of a concern than a question, but it seems like it's the planning department, by this definition, will only be accepting documents electronically submitted. I was wondering if there was any thought or provision for physical copies to be filed. Just because it only mentions electronic copies, there's no mention of regular documents. Thank you.
Before we go, Justin, you mentioned under 2.4, did you mention both C and D are of concern to you?
I'm sorry, B and C.
Oh, B and C. Okay, I'm sorry. I heard C and D for some reason. I transposed your, okay. All right, thank you.
Mr. Chair?
Yes.
Happy to respond.
Yes, Chair.
Or begin the response to those questions.
Okay.
I'm going to start backwards because I think it'll help clarify a few things. So with the EPIC system coming in, the planning department will only be accepting electronic documents. It'll be coming in through there. We'll no longer be accepting paper documents for submittal of applications. Any legacy documents, any legacy applications will be handled in a more of a traditional manner, but moving forward, everything will be submitted electronically. To the digital signature side of it, Jean, you're welcome to add to this if you'd like to, but as far as the digital signature is any form of signature in a digital format, it could be a scan, it could be a DocuSign, just basically the requirement to not require a original ink. So that will be going away, which obviously requiring original ink and requiring electronic document submittal, they don't go together. So it kind of follows suit with with going electronic. And 1-4. On the minutes, Jeff, will you open?
Sure. What we've done is as we've gone through these rule changes, not only for the Board of Appeals, but also with the Planning Commission and the Planning Department, we wanted to make sure that they were consistent with state law. And for the minutes, we had 30 days to be able to provide it to the public and put on the website. HRS actually requires 40 days. And so we're just being consistent with state law, and this is found under section 92-9.
And I guess I would add to what Jeff just said to clarify. Lawyer, I'm fussy about words. 92-9 allows up to 40 days for those minutes to come out. It doesn't mean that the planning department can't release them earlier if they're ready, which presumably they will. But it allows up to 40 days. And so, like Jeff said, we've made the rules consistent with the state law.
I just ask one follow-up question on that is, can you think of a situation where there's a requirement to respond within 30 days, but the minutes would not be available, potentially 40 days?
We have requests all the time for information, and we're required to have to respond within 10 days. That response can be something as simple as we've received your request for information, but we need more time to be able to provide that information to you. It's not a requirement other than that 10 days to be able to respond to that request. If we have the information available at that time, we'll provide it. But if we don't, then we have to let them know we need additional time to respond to that request.
And if I'm understanding Springer's question, was your question more directed to, is there a deadline that the public would have that would be less than 40 days, where the public would be required to be responding to something without the availability of the minutes yet? And I would have to look into it for sure. I don't know. My instinct says no, there is not, but I would have to look into that. So I can't confirm that right off.
I have a question. Did you, to any of the county officials, did you, in your research, determine why the state allows 40 days? Is there a logic to that?
It's just didn't really go into detail as to the reason why it was 40 days. We just, again, wanted to be consistent with state law.
Understood. Just curious if there's a basis. Jean, do you know of any why there would be 40? It's a curious number of days. We're used to seeing 30, 45, 60, 90, you know?
Yeah. I did not look into the legislative history of that, and I'm looking at the statute book online right now. I do not see anything that looks like legislative history that's going to tell us, that's going to answer that question. So no, like Jeff said, we didn't research how the state came up with 40. We just, so I don't know.
Yes, Richie Henderson.
Jim, 40 days is the standard for quarantine.
Really? Also, it has something to do with the Easter tradition.
Mr. Chair?
Yes, Director.
Not to this subject, but if it pleases the chair and the board, I can do a little overview of what the EPIC system, what the intergov system is. I think it's somewhat assumed that everyone is somewhat aware of it, but I don't think that's a safe assumption. So happy to do so if it's needed, and also can not.
We have a slight cap at about 11:45, but if it's a 5-minute review, then great. Please go.
Yeah, even 3 minutes. I mean, it shouldn't take very long. Most of you are aware.
Well, I'm starting the timer then.
Good.
My timer's set.
Most of you are aware that Hawaii County has been working on an electronic permitting system for a number of years. That is coming to fruition. Department of Public Works and Planning Department have been working together with Department of IT to stand this system up, and it's going to create an online permitting platform for both Department of Public Works and Planning. So all applications coming into the Department of Public Works and Planning will be submitted through what's called CSS, or Citizens Service Center, and it's going to be an online portal. This is all by a cloud-based software as a service type of platform. And so an applicant or a customer will be able to go online and fill out essentially an application, make themselves a profile, put all their information in there, and have an account. And then they'll be able to upload their applications for building permits, plans for whether it be a variance or a change of zone or a special permit or an appeal in this matter. And that'll go through this electronic system. So there will be no requirement for any paper. And then that'll get distributed to the various person that's supposed to go to, whether it goes to the Board of Appeals. If it's a variance, it'll go to our regulatory permit division. If it's a building permit, it'll go to DPW or the building division. This will essentially allow us to create track metrics, to have data. The applicant or the client will be able to monitor those as well. So they'll be able to see where their application is, kind of what the estimated time frame is remaining on it. It also allows for multiple agency review at the same time, and it will eliminate the need for paper. And our people will be operating in a module, so it'll also be creating a lot more consistency. We're working on creating more IOs, or intelligent operations, that will essentially one click, and we can distribute out the say the request for comments to all the agencies at one time. Sample form letters. Another really good example would be if we're doing say a short-term vacation rental application, we're doing a new placard. All that information that comes into the system will automatically populate letters, or automatically populate a placard, or automatically populate the permit. So it'll actually reduce staff time, and it will also hopefully create less potential accidents or typos, etc. And it'll like I say, we'll be able to track it there, and the applicant will be able to track it as well. So the whole goal is, more transparency, more efficiency, more flow. We still have a long ways to go on our end. So even though we're going to be going live and we stand it up on the back end of our operations, we're still building out all of this intelligence and all of the increased optionality for just really streamline, effective process, rechanging our forms, et cetera. So it's a really positive thing. It's certainly a game changer. I kind of equated to the time that we would, at one point said, time used, you could go, we would tell you, you could go online and book a plane ticket. And for the longest time, I know I wasn't comfortable early on. I still want to call the airline and say, can I book my flight that way? And at a certain point in time, we got accustomed to just doing everything online that way. And now it's pretty odd to do that. So a bit of a behavior change, but overall, I think it'll be very positive. I got any time left?
No, you actually got it to the second. You were even more practiced than our former public testifier. Thank you. Very concise. You're obviously comfortable with the material. Board members, do you have questions for the director after that? Yes, Justin?
Yes, Mr. You mentioned with regards to the lack of ability to take paper, is there any kind of contingency, like if someone comes to the desk, that a staff member might scan it in and make it electronic for them? I'm just concerned about, I guess, members of the public that may not have access to either a computer or the internet, how they would be able to go about their business.
Yeah, sure. And that's a concern that we've taken into account. Absolutely. We will have kiosks set up in the Hilo office as well as our West Hawaii office, two on both sides. We'll have a computer there, screens there. I know Department of Public Works is doing the same thing. So we'll have our staff is there to help them, get into CSS, fill everything out and go through the process as needed, as well as provide support to folks that are doing it at home and might need a little bit of support. The one thing that we're not going to be doing is scanning documents for folks. We will have a list of places that they can get documents scanned, and then we'll be able to provide that to them, and they'll be able to go get those documents scanned as needed. But somebody would basically be able to come in with a flat flash drive and upload all of their documents here at the department or at home.
Could I ask a
go
follow-up?
ahead. Sure.
Thank you. I'm just curious if the director knows, because I can't think of any off the top of my head of places that will scan documents for people.
Yeah, you can go to Office Max. It's probably the most straightforward place. You can go to their self-service machines, plug in your flash drive, hit the button, get the documents scanned in there. I believe Hawaiʻi Printing. I know there's other various. I think Longs used to have a print. I'm not sure if they still do, but we're compiling that list. So there is that capacity available.
Do the public libraries offer access to scanned computers?
I do not know. That's a good question.
It could make them a viable function in the future because hardly anybody. I shouldn't make any comments. All right. Any other questions at this time? Didn't we have questions from Neil?
No, I think Justin and Mr. Kern have answered what I was going to ask.
Okay. Stacy, did you raise your hand? No? All right. Remember, this is a motion to accept with modifications, which allows us to modify in the future. We don't have to make those specific modifications only today. Is that true?
I think you'd have to identify what modifications you want.
To reserve as as for continued discussion in the future, or we have to resolve the matter today?
Today.
All right, there's some, yes, Springer.
I did have a question or two. I think most of them have already been addressed. It was about the postmark. And I'm sorry, I didn't do a good job of making my comments tied to the item. So in the it's item line 2-4, section A, time and place. So it has to do with what we consider received, unless otherwise ordered, the date on which documents are received shall be regarded as the date of filing. It's not the part. It takes away, sorry, it's the section where it takes away the postmark date and has it. Yes, that's it. If postmarked, if delivered by mail, it's going to be the date the documents are received. And so that's because everything's going to be going into this electronic system, even appeals. So it's not like an email. It's a definite received date.
Yeah, it's a definite received date. Much like we do. I'm trying to think of another. Oftentimes we'll go set up an account on, whether it be like the Airbnb or something like that. And so at that, we basically do the same thing. You'd have an account on there. You'd upload that. That upload will then confirm that was uploaded, and that would be the date received. It'll immediately go into the system. It'll hit our system. The clerk will get it, and it'll go out for distribution.
Okay, so it's not like an email where there could be arguments about, well, was it when I sent it or when you opened it, or it's just there's going to be a.
There's going to be a date on it. Jean, do you want to expand on any of that? But
no, I think that's good.
I think you got that. Yeah.
Yeah. So if somebody is required to notice their the residents in their community, that's not going to be through the electronic system. That's just certified mail. So is that a postmark date or a received date? And I'm sorry, I realize the heading here is filing of documents. So that might be in another section of our rules.
I believe if I can jump in here for a second, I believe the notice to neighbors is mailed because, an applicant may or may not, or an appellant may or may not have an email address for everyone, but all of the neighbors' mailing addresses are available through the real property tax website. And so notices to neighbors say, if I were going to be appealing something and needed to send notice to all my neighbors for my BOA hearing date. That is something that's still allowed to be and basically required to be done by mail. And I'm afraid I've closed my set of the rules, and so I can't immediately point you to that. Maybe Jeff can jump in. He's probably faster with the rules than I am. But that's something that does still go out by mail. So there are, it's because that doesn't run through Intergov. What I would do is I would send my mailed notices out to all my neighbors saying, hey, this date is coming up. Then I would turn around and the evidence, my affidavit to the board saying that that's been done would be submitted through Intergov.
Mm-hmm. I think we might need to add back in something to clarify, maybe in the service of process section, that whether we're looking at the postmark date or the date that the members of the public received that notification, if they then have the right to act 30 days after, within 30 days after that, we need to have a firm date there.
Could you repeat, please, Springer, for clarification?
Yeah. Sorry, I know that was a little scrambled.
And if you could, I'm sorry, could you give us the section of the rules that you're in?
Yes, section 2-6, service of process. It still does say that service of papers or documents shall be made personally by first-class mail or by other means authorized by law. Because I think before the date was, I think right here we need to include what we mean by what's considered served. What is it, the postmark date or the date of receipt?
Springer, I think that's covered by subsection E, which defines when service is complete. It says when the document is stamped and addressed and deposited in the U.S. mail. So that sounds like it's the postmark date.
Thank you very much. That was my big question. Apologize.
Thank you, Justin, or whoever jumped in there.
Mm-hmm.
That was Justin, our attorney on the board.
I did have
yes, Springer.
Sorry, one last one. Section 2-7. I really apologize. When I click on my comments, it goes to the right section, and then it quickly disappears. I don't know what just happened. Okay, it is section 3-13. G, number 1, the form and size of exhibit documents. I think the editing may have just gotten this statement a little screwed. It's because it's talking about what you do to fold papers to make the map the right size. If we could just simplify that a little bit to documents shall be legible and formatted to 8.5 by 11 in size, and just delete about to the respective approximate size where practical.
Okay. Is there any, yes, go on.
And then just one more clarification in 5.3, section E, oral and written presentation. I think they did a great job of going through and striking out any place where it says and 10 copies of. We no longer have, no one has to deal with that anymore. But sometimes it doesn't quite make sense if you're submitting an original through an electronic system, what does that mean? Should it just say the document? I just don't want anyone confused about how do I make this original. People that are still used to wet signatures and paper, trying to figure out how do I provide something that's adequate. Could that just read the document? Or just strike that word "an original" and say, any written comments, recommendations, or replies shall be submitted electronically. You don't need the word "an original" there.
I don't have a problem with that, and I think that makes sense.
Thanks.
Yeah, I don't have a problem with striking the word original.
Do you want to say replace where it says original with the document or with document?
Either, yeah, depending on the context, it either makes sense to just strike it or replace it with the word "the document."
Sorry? What is our clause? What is our, for the record, the specific clause?
That one was 5.5-3E. There's another one at 7-4.
I think, Mr. Chair,
Yes, Richie. Yes, Richie.
I think that the language there is to allow for the 10 copies to be included with the original. So maybe if we're not requiring the 10 copies anymore, maybe the whole line isn't needed. Does that make sense?
It could. Yes.
I think at
Stacey.
some place you do need
I have a
Stacey?
question.
Yeah.
So didn't we just establish that 10 copies is no longer a process? Everything is electronic, correct?
Correct.
Okay. I think there's one other section, 8-7, that still refers to an original and 10 copies. So again,
So I'm sorry, Stacy. What we can do is looking at the, the understanding of the board is when it refers to an original. I mean, we were just trying to do this quick and simple just by deleting the copies, but it does make sense that maybe we should just refer to the petition and keep it at that, because that's the main thing. As far as the first section regarding testimony or comments, we can just say any written testimony or comments can be submitted electronically. We can clean that up pretty quick. But yeah, that makes more sense, and it doesn't get so confusing. So the last one, I'm sorry, Stacy, was 8-7.
So same category of just cleaning up consistency.
Yeah, what we can do is take out an original and 10 copies of, and just create the petition shall be electronically filed with the board.
Yeah.
And same with the one in section 7.
Chair Cully?
Yes, Neil.
Maybe we can save some time here. If you have this document up in Acrobat, if you simply type in the search field, the word original space bracket, then you'll come up with all of them. I just did that. There's a whole bunch of them. So that's probably the quick way to find the ones that you want to deal with.
I'll bet Rob and Jeff do that all the time. One thing I'd like them to type in those brackets, Neil, using Acrobat, is notice. One of the issues that's bedeviled the board in the past has been notice. What constitutes notice? Because you have, a public notice, you can have actual notice, you can have a constructive notice, you can have an implied notice. There's lots of different notices. Yeah, Jean?
I think for purposes of board action, we probably aren't looking at getting into all of those different kinds of notice. We need actual, for an appellant to do something, to trigger the board to, do something, the board isn't going to accept an implied notice. The board needs to have received proper real notice. So.
Yeah, in terms of our rulemaking for how the board operates, this actually extends more when we have petitioners in front of us or members of the public. And that's where it bedevils us in the past is, what constitutes proper notice. So I bring it up as an editorial aside. Since Neil provided a tool that I didn't know about. Okay, let's go back to Springer's issues. Springer, are you comfortable with what's been observed today?
I'm happy with the discussion so far. I did have one more thing I think we need to address.
So just to clarify though, we'll be striking original with either the petition or petition and / document or related document.
Mm-hmm.
Okay.
What section? Yeah, what section?
In all the sections, Director?
That's my thinking. We'll just do a blanket. Anything that's original will replace as either the petition or related document.
So it's throughout the rules.
When it's related to the original, as in the form of that original document, yes.
Okay. Maureen, is that clear?
Yes, I think it is. I think it's sufficiently clear.
Council accepts.
Thank you.
Anything else?
Chair.
Yes, Springer.
So we've talked about the 40-day change a little bit, and in section 8-13, proposed finding of fact, the parties have 30 days after the close of the hearing to submit their proposed decision in order and findings of fact. If they do not, I'm not sure how much this is an issue because before they would have been, it's only available at day 30 and the findings of fact were at day 30. Maybe it wasn't critical that they have those, but to submit the fact before the minutes are available could be problematic. So I just took it out to other folks for discussion.
Okay, this is 8-13.
Chair, I think if I may, with findings of facts in the past, after a hearing or a decision has been made by the board, typically that is discussed as the next step and is determined, and we sort of, depending on the hearing, determine how long it will take to do the minutes and work that out with the parties in terms of who's drafting the findings of facts and how much time they will need. And usually that's determined at that point, which I think is covered under proposed, unless specifically waived by the board or the presiding officer. So I'll leave that up to you all to determine if that's sufficient, but.
Where is that language?
That's in 8-13.
It's on page 8-4.
I think that's fine. Because we usually determine sort of that time frame
Yes.
at the conclusion of the particular petition once a decision is made.
So you can have more than 30 days.
Yeah.
Chair?
To deliver. Yes, we will. Yes, please go on, Neil.
A quick question, if you will, on what we have in front of us. Are we considering only the proposed changes from the planning department, or is the whole document now fair game?
Just the proposed changes from the planning department.
Okay, so the discussion of 813 is something we couldn't fiddle with it, right?
Fair point.
But I'll chime in. I'd say it's relevant because of the other change that we're having with the 40-day change. So the nexus between those two, I think, would be reasonable to have that discussion around that, to make sure that one doesn't take out the other.
I get it. Thank you.
I thought the issue was that the minutes might not be available within 30 days, but the proposed findings need to be submitted within 30 days. But there's a mechanism to provide additional time to submit the proposed findings, right? So it's really not a problem. I would be concerned about changing the 30 days in the rule 813 without having that notice to the public.
Thank you. I think that addresses my question. That makes sense.
Because I think the greater question would be, do we change the other requirement back to 30 days, not to change 813 based on it conflicting with the other. But if both are going at 30 days, then I think, to Springer's point earlier, it kind of cuts itself out anyways. It'd be different, I feel like, if we had to have like the minutes done in 20 days and the findings of facts had to be in 30 days, then you would be banking on those potentially to create your proposed findings of facts.
Oh. All right, so Springer? Oh, I'm sorry, Justin.
Sorry, I'm gonna move past topic. So if Springer has more to say, I'll defer to her.
Springer, are you comfortable at this point with this matter?
Thank you. Thank you.
Okay. All right. Wait, before we go, so as far as 813, we're clean.
No change.
No change. All right, Justin, you're on.
Thank you. I just briefly wanted to circle back to what Mr. Kern was saying about switching to electronic documents. You mentioned that a decision was made not to have planning staff scan documents for members of the public. I was wondering if you could expand on maybe the thinking behind that decision.
The rationale behind that decision was primarily a bandwidth, a tooling issue, as well as I think it's different when we get involved in scanning those documents for completeness. And if something wasn't, say, complete on that end, it could come back and say, you know, it's because planning department staff didn't do it right, versus relying on somebody to be complete within their side of it to make sure that their documents are complete. I feel that's different than having staff or having a kiosk available for somebody to upload their documents in their complete manner, or as they feel it is complete, and walking them through, here's how here's how you're going to create your account, put your email in here, put your address in here, etc. I don't think it'd be incumbent upon us to take on that position.
Justin, what's driving your concern?
I guess I'm analogizing to the courts. A number of years ago, the judiciary switched over to electronic. I can't remember the last time I filed something in paper, but I know that option is still available at the filing window. I don't think the courts necessarily take a position that if someone filed a defective document, that's the fault of the filing clerk. They're just filing whatever the party wants. I guess my bigger concern is still regarding access. I think it's somewhat alleviated because of the kiosks there. I guess what the public testifier mentioned about, certain individuals might have difficulty with technology, it still would be somewhat of a hurdle. So I guess the easy solution would be to have maybe someone from the planning department help with just regards to scanning documents for them. And if it's defective, I mean, the planning department can send a notice to them saying, hey, you didn't send what you needed, or et cetera. Because I was reading over some of the record of the cases that were continued for today, and the planning department basically sent responses to some of the petitioners saying, hey, it's defective, you need to do X, Y, and Z. I'm not sure if it can be fixed by the rule changes today. That's kind of what's giving me pause. I don't think there's, I think that the issue is probably more with the electronic system. So,
Richie Henderson.
I have a feeling that what the director is trying to not necessarily skirt, but we don't want to have the planning department actually teaching people how to use a computer. And I think, that's really what this is going to come down to. I don't know how to use a computer, teach me. And I see that as one, not appropriate for money spent on employees in the planning department to be educating the people on how to use a computer. There are classes available, the university is available. They can go and get the education that they need to do that if they're serious about what they want to do. I don't think we're going to see very many people that aren't basically computer literate. But having said that, I know there's a lot of contractors that they don't do computers very well. They pound nails and do that. And it's usually the wife that's taking care of the administrative stuff. I think that what Director Kern has said, that, they'll give them the basics of how to put it in there and access it is fine. But, really to say, you got to scan this and scan that and put this in, basically, doing their job for them isn't really applicable to what should be happening with this kiosk situation.
And to add to that a little bit, it'd be the equivalent in a sense where currently we need to have an application. We need, let's say it's a rezoning application. We need the original and 20 copies of that application. If the person was able to get maybe handwrite out the application side of it, and then they would come to our department and say, you guys do my copies. You guys fill out the rest of it. You guys tab it. You format it. We don't do that, right? If somebody comes with an incomplete document, we go back and say, you need to go, here's what you need to do, tab it, format it, and insert it. I think it's just going to get really tricky at the front desk if we're there trying to teach people how to do computers, but we have the computers available with instructions and we'll be guiding them through it. But to say, here, now go through and scan all my documents in there, tab them, save them, and all the rest, when you can go to Office Max and do that. The same way that an applicant would have probably go to do their original copies if we were doing it, or to do the paper copies. Similar situation, right? At some point, copies are going to have to be made. And if you're making copies, you can probably scan. We don't make copies for people in the department, nor do we scan for that matter. We'll scan our documents, our files that we have, and send them to people so they have access to those records, but that's more on the backside.
And I'd like to continue by saying that with this change in all things, technology and economies start to be created. So there are going to be people that are going to have the opportunity to create the business that says, hey, not only am I a planning consultant, but I can assist you in filing your documents. And so I just think we let the marketplace kind of take care of that end of it.
Justin?
I think Director Kern's analogy with regards to copying and scanning is pretty much on point. I don't have much more to add. Thank you.
All right. Yes, Stacy.
I may have missed this part, but I'll ask this question. So is there a transition or grace period? So a person comes in to file their appeal, and I think the 30-day deadline is always the question that tends to come up in front of us in front of you, Chair, to make a decision whether it's a valid case or not. Is there a grace period? Somebody walks in with their 10 sets and says, I'm here to file my appeal, and it's the last day. How are we bridging the gap between the electronic system and someone walking in ready with their 10 copies?
From the planning department side, we're obviously going to give latitude where it makes sense. A similar situation came up because we're basically shutting down taking on new applications from the 16th of July to the 28th. 28th is when we'll start accepting applications. So if somebody had a deadline that was within that period, we're going to extend it by whatever that time period would be. And in my mind, if somebody came in on the 30th day with their copies, they didn't get the message, we're going to say, we'd happily extend that a couple days to give a fair and reasonable opportunity for somebody to be able to take those actions. I don't think we can do anything that would preclude that. And if anything, I think we'd err on the side of inclusion for those things. They came in, 30 days later, I'd be like, I think you're really late. But you know what I mean? A day or two, absolutely. It's very much trying to be just, fair and transparent, as well as having some flexibility while we go through this transition. It's going to be a little bit of a bumpy road, and want to make it reasonable for everybody, which is also one of the reasons we're trying to do a lot of marketing out there. I'm not sure if you folks have seen it, but we've been on the radio, we've been in the newspaper, we've been on social, we have signs on the door, trying to tell people this transition's coming. Please be aware of it. It's in our emails, underneath our signature lines, trying to be informative as we can be, still knowing that some folks will come in and be like, I've never heard of this, and I'm ready to go. Okay, well, sorry, here's what you need to do. Here's the new process. And of course, you need 2 more days, no problem.
Thank you.
Director Kern, I wonder if, I'm a little embarrassed. I know all about this EPIC system, except that it applied to us. I didn't realize that, the original, when you're submitting your plans, that's when it would be electronic. So I could easily see how a member of the public, could really need that 30 days, because it takes a while to get your whole thing together, and maybe really does not have any idea that any of this is happening, because they don't pay attention to planning department things. It doesn't even occur to them that it matters to them. So I wonder if you could commit to like a firm at least 30-day window where you would still accept those paper copies.
Well, we can't accept accepting paper copies. Once we transition, that can't happen. What I can do is I can allow the latitude within that for the person to go and get it, digitized, which is probably digitized in the first place. But if they came in on the 30th day, I'm not gonna say, oh, so sorry, you didn't get the message, you're out. What do you need? 2 days, 3 days, 4 days? I would absolutely. We've done so in the past. I've seen something come in where somebody wanted notification on a certain action, and maybe staff forgot to give that notification on that action, and it came in later, and the person that was inquiring about it said, I missed it. You guys didn't inform me this one time. I said, you know what? We made the mistake. Absolutely. I'll open that window back up. You have every right and ability to do that, even though it was after the fact, that you could file that if you'd like to, because we missed it on your side. And to me, it's very fair and very logical, but I can't open it up to accept paper. I can open it up on time deadlines and windows to be fair and reasonable. Is that acceptable?
Yes, thank you. That's much better way to put it.
Yeah, so that's going to be a policy that you establish for this transitional period. We don't need to rulemaking on that.
No, and as I say, we're going to err on the side of inclusion. That's my feeling.
Yeah. Okay. A question on InterGov, and I'm sure this has been addressed in depth in other forums, and that is redundancy. This is going to be completely cloud-based.
Yes.
So, there's that legendary overweight kid in New Jersey sitting on his bed that can bring everything to a halt Do you remember that guy?
I don't know. I don't think so, but
Our previous president alluded to him. Anyway, it's stated, we're all vulnerable to security breaches or lapses. And then we're also vulnerable to relative, let's just call it incompetence or mistakes. Mistakes happen. So I'm just curious what the county's capacities are to get back online, since this is going to be what drives our entire system.
Yeah, so a couple things. So because InterGov is SaaS or software as a service, it's all cloud-based. So as long as we have internet access, we're accessing our system. It is possible that InterGov, the Tyler system, may have a glitch and may shut down for a minute, and we'll have to deal with that with any type of technological issue, like we deal with that with Outlook currently, and it's something that we have to work through. But the redundancy with it being cloud-based is actually better than it being stored on a server. We will also be having our primary repository be Laserfish at the same time. So we still have all that as a backup. And what we're working on as our phase 2 to this is to link up Laserfish and InterGov together. So we can still have our primary within the Laserfish on at least a double redundancy backup on our side of it. I will say this isn't a software that's just being used for Hawaii County. LA County uses this as well, which is a pretty big county.
Yeah, I've heard of that place.
Yeah, they got a few folks over there and a few. So I haven't had any concern or any major concerns come up around that side of it. I feel like that's pretty sound from a SaaS, because they deal with multiple servers and they have multiple redundancies on their end.
Okay. Neil?
Just think of all the new jobs that are created. In the 15th century, Gutenberg invented the printing press and put all those monks out of business who were sitting in monasteries copying Bibles.
Yeah, it also started the 100-Year War. Anyone else? Jeff.
Thank you, Mr. Chairman. Consulting with our corporation counsel, we were thinking that we might want to make one addition to a section in the rules, section 2-6, regarding service of process. The subsection E at the very end, we'd like to add in the phrase that's at the end of D, which says, or by other means authorized by law. And that would go right after United States mail, because again, that's what we're trying to do, have that option available as authorized by law for service. At this time, those things change. We don't want to get so specific that we are boxing ourselves in like what's currently the process. So if that would be okay with the board, just adding in that phrase to that end of E.
I'm sorry, could you repeat the page and the subsection?
This would be page 2-3, section 2-6E. And at the very end where it says in the United States mail, we add or by other means authorized by law. Similar
Would
to.
Would that include a private carrier like a FedEx or something?
Whatever is authorized by law, sure.
Okay.
At some point, they may allow electronic service, and that's why we want to keep it general to be able to capture whatever changes occur.
Okay.
Thank you.
All right. Anything else from the board members regarding the Springer's motion, which is modifications of these rules, proposed rules? Hearing none, I'll call for the question. I'm sorry.
I think it would be a good idea to state all of the modifications, right?
Okay, if I'd been writing them down, I would.
So,
So for the record, can we read into the record? April, do you have a grip on this?
The main one I have is to delete the term original as it pertains to submitting documents so that it says the petition instead of the original of the petition.
I think it was going to be delete the word original and replace it with petition or document, depending upon what would be appropriate for that particular section.
Correct.
That's correct.
And the only other modification would be the one that Jeff just mentioned. But you should clarify that there's no other modification.
Okay, so were you able to hear our Deputy Corp Counsel advise and April what the two modifications that are proposed are? Are there any other modifications the board members intended to make? All right. Thank you. And with that, read into the record. Yes, Springer?
I think we missed one where I had requested to fix item 3-13 evidence, item G1. It had to do with folding paper. It was to,
Okay, for the record, this is on page 3-4. That's under evidence 313G. Go on, Springer.
to simplify item number 1 to exhibit document shall be legible and formatted to 8.5 by 11 in size.
And then delete the remaining of the.
Of that sentence.
Thank you.
You're in agreement, Jeff?
Yes, I have them. Thank you.
Yep,
All right.
agreed.
Director Kern agrees.
So the period is after the word size.
Not exceeding 8.5 inches in size, period.
Deleting
Correct.
or
By
to the
11.
respective approximate size where practical. We're deleting that part.
Yes.
Yes.
The next, then it would end, would continue with,
Keep the last
Yeah,
sentence, whenever practicable, sheets of each exhibit shall be numbered and,
et cetera, data and other figures.
yes,
Okay.
and other figures shall be, yes. Okay.
Sorry to reopen discussion, but is there a situation where petitioners might not be able to fit a 8.5 and 11? Like if they're trying to upload plans or maps?
Yeah, it is in 2.4 B1. Under formal requirements.
Your plans
for
come
filing
in
of
a digital format already.
Justin,
So
do you
I
see
guess
that?
what I'm hearing is that the maps and whatever unusual sizes is already covered under 2.4.
Yeah, do you see how in exhibits it refers back to Rule 2.4?
Okay,
Under G?
thank you. I see that now.
Yeah.
Okay.
And then that exception is made under the previous subsection. Agreed?
Yes.
Okay. So we have the 3 modifications that have been read into the record. Anything else? If not, I'll call for the question.
Okay, Chair, the motion is to approve the changes to the rules with the modifications, and I'm noting that we have discussed the 3 specific modifications. Ms. Kay?
Aye.
Mr. Henderson?
Aye.
Ms. Aguiar?
Aye.
Mr. Lee,
Aye.
Mr. Thomas,
Aye.
and Chair McCulley.
Aye.
Motion passes.
Thank you, April. All right, next item on the agenda is our approval of the June 18th, 2021 minutes. Has everybody had a chance to review the minutes? Yes, April?
So a point of clarification on this last item. Normally, with a regular petition, we would have findings of facts. In this case, we will amend the rules and go through the rule, chapter 5, in terms of the rule process, get chair signature and process accordingly. So I just wanted to state that on the record, and if you had anything to add that needed to be acknowledged.
There is a specific procedure where it has to go to the clerk as well, but I have nothing to add.
Okay, great. Thank you. Sorry.
Thank you, April. Okay, I'll go back to my formal previous request for the June 18th, 2021 minutes. Did everybody have a chance to review those minutes? If so, I'll take an entertain a motion to approve.
So moved.
Thank you, Richie. And a second? Thank you, Neil.
Neil, second.
It's been moved in. Any discussion? It was seconded by Neil. Discussion on the minutes? Hearing none, I'll call for the vote. Roll call.
I could be all in favor.
Oh, all in favor? We'll skip the roll call. All in favor, say aye.
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 Opposed, same sign. Hearing none. Thank you. Administrative matters. Our Deputy Corporation Counsel provides a status for the update on appeals.
There's nothing new to report on those.
Thank you. And then staff, April, is the status of outstanding Board of Appeals petitions.
I recently sent everyone updated petition cases. For the August hearing, we have 6 petitions currently on the schedule. 2 of those are DPW cases. 2 of them are related to the LUC, so I don't know at this time if they will continue or not. And then one of those petitions with the Planning Department looks like it may settle prior to the hearing date. So hopefully for August, we will have fewer than 6 petitions to hear.
All right. And we have Mr. Olcott to look forward to.
Yeah.
Let's see. We don't have any announcements, do we? Except I will point out that our Deputy Corporation Counsel, Diana Mellon-Lacey, has gone on to greener pastures, primarily working in finance on the monetary side for the county. And we now have our representation. This is my 4th Deputy Corp Counsel. This seems to be a hot potato of an assignment. And we'll see how much fun we can have with Ms. Martin. So welcome to our Board of Appeals, Lauren.
Thank you.
Our next meeting date is August 13th. I now entertain a motion to adjourn. Richie does. For a while there, I thought nobody wanted to leave. Thank you, Springer, for a second. Let's have a roll call vote.
Also be
we can, April's very compliant today. All those in favor say aye.
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 Opposed, same sign. We don't want to hear that. All right. Thank you. We are adjourned.
Thank you all. Have a great day.
Thanks.